I hereby call this. Thank you. I hereby call this interim meeting of the Joint Committee on the Judiciary to order. Mr. Clerk, would you please call the roll?
Senator Berg. Senator Carroll. Senator Nadine. Here. Senator Neal. Senator Schickel. Here. Senator Stivers. Senator Storm. Here. Senator Turner. Senator Wheeler. Here. Representative Banta. Present. Representative Blanton. Here. Representative Bratcher. Representative Bray. Representative Burke.
Here.
Representative Decker. Representative Dietz.
Here.
Representative Doan. Representative Flannery.
Here.
Representative Griffey. Representative Herron.
Here.
Representative Kulkarni.
Present.
Representative Lewis. Representative Maddox. Representative Mosier. Representative Nemus.
Here.
Representative Petrie. Here. Representative Rawlings. Present. Representative Sharp. Representative Stevenson. Representative Wilson. Here. Co-Chair Westerfield.
Here remotely, Robert and Mr. Chairman. My apologies for not being able to be present. I've got to take one of our triplets to the hospital this morning for a checkup.
Co-Chair Elliott.
I'm here. So it's good to see everyone, and I hope you're enjoying the fall weather. I've tried to avoid turning on my heat. I've been using a little fireplace, and I think this morning I'm not as tough as I thought I was because it's gotten pretty cold. So also a member of this committee I know who is still in the hospital, Senator Turner. I think his prognosis has improved. So do you have an update, Senator Wheeler, on Senator Turner? Not to put you on the spot, but I know he's a member of our committee, and we're concerned about his well-being.
I've maintained, contact with his daughter, and he is continuing to improve, albeit slowly, given the extent of his injuries. But we're hoping to have him back into Kentucky soon. He is, he is conscious, able to make decisions, and wants that as well. But they want to make sure that he's fully stable before they get him up here, and we're all looking forward to it so we can see.
Good. Well, send him our well wishes.
Certainly.
Our first item on the agenda is the uniform law proposals. Oh, no, I'm sorry. I need to approve the minutes, don't I, from September the 9th. There's a motion. Is there a second? All those in favor, aye. Aye. Those opposed, no, and the minutes are approved. And so, getting ahead of myself, Mr. Berry, who is with the Uniform Law Commission, will have a presentation on uniform law proposals. And if you would introduce yourself for the record, and then you may proceed.
I will. Thank you. Thank you very much for letting me be here. My name is Turney Berry, Turney Berry. I am a lawyer in Louisville with White, Tarrant and Combs, and y'all have been kind enough for almost 20 years now to have me as one of the Commonwealth's uniform law commissioners. So thank you for that. Over the last, half dozen years or so, maybe a little longer, y'all have done a really remarkable job of moving Kentucky's trust law along so that we are compatible with and competitive with our surrounding states and much of the rest of the country, which we appreciate, which helps us keep work here, keep money here, keep activity here. So that's all a good thing. We have a couple of things that would really, in a lot of ways, complete that effort. There are 5 acts that you have in a packet someplace or the other. And I thought what I would do is just tell you what they are and what they are generally trying to do. And then you can, as we go, see what you think about them. My instinct is that they ought pretty much to be non-controversial, but I've been married a long time, and I know that there are a lot of things I think are not controversial that turn out to be quite controversial, as a matter of fact. So y'all may have the same view. I can do these in any order, but I'm going to do them in the order that I happen to have here, and probably in the order of the most broadly applicable. The first is something called the Uniform Directed Trust Act. The concept of a directed trust is really pretty simple. You have as you know, when you have a trust, somebody creates the trust. We call that a settlor or grantor or something like that. And then we have beneficiaries. And the person in between who administers the trust is the trustee. Usually that works pretty well, but sometimes, two particular kinds of instances, it doesn't work perfectly. One of those instances is where I've got, for example, minor children, and although I love Worthy National Bank, and they're going to buy stuff if my wife and I die, they're going to buy stuff that goes up, so I'm happy to have them as trustee. I'm not really thrilled with them making decisions about where the kids go to school, or can the kids go on spring break, or how much are we going to pay for college, that kind of thing. So I want some of my family members to advise and really direct the trustee. A lot of times we call them advisors, but if you read the documents, they're really directors. And we've had that in Kentucky going back a long, long way, going back until the 1920s. In fact, we have one of the first cases in the country that says that these advisors are in fact fiduciaries, have the same fiduciary duty that trustees have. That works pretty simply. The one that doesn't work quite as well is I've got the family farm, and I really want the family farm held for my grandchildren. Otherwise, I'm happy to have Worthy National Bank be the trustee, or to have my Aunt Mabel be the trustee. They're going to worry, whoever the trustee is, that at some point, shouldn't we sell the farm? None of my kids want the farm. And I've said, well, I want help for my grandkids. I know my kids, I didn't raise them very well, but my grandkids I'm more optimistic about. And at some point, the trustee is going to say, well, that we worry about that. We worry that somebody's going to say, if we bought Apple stock, it'd go way up or whatever. And the solution to that, and this is a national solution, been around a long time, is you put some family members or friends on and you say, tell the trustee, don't sell the farm. Now, you can never sell the farm, right? I mean, it could very well be odd circumstances or whatever. You know, there were a bunch of people in Rochester, New York, who had directions never sell Kodak. Well, you know, Kodak was a pretty good company, and then poof, the whole film industry disappeared. So there's always some flexibility, but having a direction is good. What the Directed Trust Act does is it says that if a trustee follows the directions of the trust directors, then it has no liability unless it's engaged in willful misconduct. So if the trustee, wires money to the Bahamas for no purpose or no beneficiaries in the Bahamas, or does something that is for its own self-interest or whatever, then it's going to have liability. But if what it does is there can be an argument about whether you should have kept the farm or you should have kept the family business or whatever, then the trustee is protected for following the direction of the trust directors. Now, the trust directors have their own liability. So if somebody appears on your doorstep, some lawyer appears on your doorstep and says, do you want to be on one of these committees? You just have to remember that you step into the role of a trustee, and you could potentially have your own issues. But that's the nub of the Directed Trust Act. It's been adopted across the country in I think about 20 states, which is pretty good. It's a pretty popular act, and I think Kentucky would be well served today. If we want to have a true directed trust to protect the trustee, we have to go to Ohio or Tennessee. If we go to nearby states, you can go to Delaware, you can go to Alaska or Nevada. Not many Kentuckians, when you tell them you want a Nevada trust, they think you're automatically doing something suspicious. But Tennessee or Ohio, they can at least see them, drive to them if they need to. And there are trust companies there that get a lot of business from Kentucky that we just soon not have. Happy to stop there if you've got real questions about that. Otherwise, I'll go on to something parallel to canting. All right, Mr. Chairman.
Senator Berg has a question.
Thank you, sir. Very interesting thought processes. Why not just appoint the person you want to be the director as the trustee? Why do you need a double layer there?
Well, it's a great question. Thank you very much, Senator. The reason is generally because let's say the family members don't want to do all the things that a trustee has to do. Trustees got to line up filing tax returns. They got to keep records. Maybe what you have is a trust where I've got the family farm and I also have some investments. Well, somebody's got to deal with the investments. Somebody's got to talk to the beneficiaries and say, here, pay the tuition and that sort of thing. People don't want to do that piece, but they're perfectly happy. You might be perfectly happy to sign on to my trust to say, I'll be happy to listen to somebody who wants to have the family farm sold, because I know that mostly Mr. Berry didn't want the family farm sold. So it'd have to be an unusual circumstance. So it's a special kind of situation there, if that makes sense. Okay. Very good.
Representative Flannery.
Thank you. I guess my question would be, this uniform law, how is it really different than what we can already do in Kentucky? Because, I mean, my understanding on some of this, you can already do this, and it sounds like some of the things you're talking about would potentially, you could have a limited power of attorney. So an attorney, in fact, could do most of this. You could have a person listed as I've seen them called advisors in trust, but I guess what's different about this proposal?
Sure, thank you. So what this does is today we do exactly what you say. The problem is that the trustee is not protected. So what happens is that if you have the trust directors or advisors, call them whichever, the trustee still has to make an independent decision that the farm or the apple stock or whatever it is shouldn't be sold. And so if you have something that's really likely to run for a long time or involves a lot of money, what you end up doing is you end up hiring an out-of-state trustee. There are out-of-state trustees that exist for this very purpose. Cumberland Trust Company in Nashville, Tennessee would be an example. It's a wave the flag trustee. What it does is it says, you got to direct us on everything. We're not going to make a decision. But you come down here and you pay us, and we handle everything. And we'll do that for not much money because we are totally protected. And so you can talk to almost every trustee in Kentucky, and they'll say, "Oh yeah, we've lost business out of state." So that's what we're trying to equalize, if you want to call it that.
Senator Wheeler.
I mean, how much money do you really think's flowing out of state? Because I know very few large financial institutions, in my experience, if they had the opportunity of managing a very large asset and essentially increasing the amount of money they had on the books that are, as far as a trust fund or trust funds go, that they're going to pass on that opportunity.
Well, so that I think you're correct, Senator. It's not really that the financial institutions are passing. It's much more that the lawyers and the clients are passing. So if you came to me with one of those situations, big family farm, family company or whatever, and you said, I want this to go on multiple generations. I say, fine, who do you want to be trustee? Well, I want Worthy National Bank such and such to be trustee. Almost certainly Worthy National Bank would take the money. But my advice to you is going to be, look, at some point, if half the beneficiaries start complaining to the bank, that's going to be a real problem. And I will just tell you, eventually, if it goes on long enough, they are likely, not because they're bad people, but it's just the way the world works, they're going to sell the stock or sell the farm or whatever. What you need is a true independent directed trust where there's not liability on the trustee, and then you can put a committee of 3 people, 5 people who can direct the folks, and you're in good shape. Now, I have no idea, to your real question, how much money. You know, that's a fascinating kind of a question. I can tell you that there are, when they move, they're big numbers. There was a big company in Kentucky that was several $100 million, and it's now being handled in Nashville, Tennessee, by Cumberland Trust Company for this very reason. That's a focus group of 1. I totally admit.
Brief follow-up, if I may, Mr. Chairman.
Very briefly.
Yeah. So I guess as I can remember in trust and estates, they talk about how it's generally policy that you don't want the cold, dead hand constantly intruding into the world of the living. Do we really want to encourage, I guess, folks tying up real estate or companies for generations like that? Does that not kind of maybe stifles? And I understand it may have belonged to a certain person that built it up, and I'm not saying that their wishes are unimportant, but at the same time, they're not there to see what's going on. You mentioned the Kodak example. I'm sure if that person had been living and they saw the collapse and they saw the digital cameras everywhere, they'd probably get rid of that as fast as you can. Is that something that we really want to encourage in Kentucky?
It's a great question and policy question. What a directed trust is trying to do is steer down the middle. So around here we have a lot of documents that say, "Thou shalt not sell the family farm. Thou shalt not sell this or that company." That's what they say. And you never know quite what to do with that because situations change. So what you're trying to do may be successful or not, as you point out. We're trying to put some individuals who can exercise judgment in the middle of that process, because we don't want to tie up things forever. I don't know if I'm right about this, but I'm told that where Wall Street in New York was once Alexander Hamilton's family farm. Well, I don't know much, but my instinct is to say cattle down there is not really ideal. Somewhere along the line, we ought to have done something different. So you're trying to exercise judgment. At the same time, you don't want it to be a stampede, which beneficiaries might like. So that's our theory behind these things.
And I think we have a rule against perpetuities, a life in being plus 21 years. So some of that is taken care of, and as you know, as an attorney, the clients give us the objective, and we don't make the objectives for the clients, and we tell them what's within the law. But I understand what you're saying here is that there are situations where this could be useful, and so that's why you're here, obviously, to present it. Right. I know you have about 4 other things that you need to go through, so if you'd go ahead and go through those, I would appreciate it. You have about 15 minutes.
Okay. The second one is something called the Uniform Trust Decanting Act. And let me say to you that, number one, in response to a couple of these other questions, we have a Trust Decanting Act now that we did, and by we, I mean back when the Kentucky Bar Association allowed us to have a legislative committee for probate acts, which we can't do anymore. We actually created an act which y'all very kindly approved a number of years ago. It's not a uniform act, and it allows folks to do some things that probably create certainly could create problems. And the Uniform Act solves some of those issues. But having said that, we're talking about marginal improvement. I'm not here telling you that this is penicillin in 1945. I mean, that this is a marginal improvement. Let me give you, what in the world is a trust decanting? Well, it comes out of the wine term. Here's the idea. I'm a trustee of a trust. I can create a new trust for the beneficiaries, and I can move the assets from one trust to the other trust. I can only do that if I have discretion to give the assets outright to the beneficiaries. If I couldn't give the assets to the beneficiaries, I obviously have no business creating a trust for them that says heaven only knows what. So that's a very useful idea. Mostly it's useful because the tax world changes, and I got a trust drafted in 1980, and it creates all kind of problems today. Sometimes there's another issue. Sometimes, for example, you have a child or a grandchild who has a particular disability or is a drug addict or something, and you want to make a change. And this is a trustee function. Trustee has liability if they get it wrong. Our existing act allows a trustee to do that in very broad circumstances, including where the standards of the trust are limited. The Uniform Act is much stricter, and it says you can only do it when you have this broad discretion. If you had narrow discretion, you can't change those standards, which I think, quite frankly, is what most clients, most people creating trusts expect. If they write in a particular standard, they expect it to always be followed. And so in that sense, the Uniform Act, it's been adopted in about, 18, 19 states, I think is an improvement. But if you said to me, Mr. Berry, we do one trust act a year. You're lucky to get that because we're busy. I get that. That's why I started with the Directed Trust Act. It'd be a big help. Decanting, if it's there, would not do us any harm. You wouldn't be ashamed of it. It'd be something you'd be proud of, and there we go.
So if I just briefly, if
please.
I can stop you. So if I understand you correctly, you're saying that this Decanting Act would narrow Kentucky law. We have a broad ability now for a trustee to divest from one trust into another. This would narrow that
correct
power. Is
That's
that right?
Correct.
Okay.
At some point, we'll probably have to narrow it anyway because sometime between now and the end of eternity, the IRS is going to issue rules about decanting. A long time ago, back in 2012, when the Uniform Law Commission started this decanting project, we went to the IRS and said, are you nice people going to issue rules? If you are, we'll stand by because we don't want an act that goes one way if you're going to go another way. They say, no, we're not getting to it anytime soon. Well, they still haven't gotten to it. So whenever they do something, we'll have to conform. But we think we did a lot of consultation with the IRS Treasury when we did this act, and so we think it kind of jee-haws there to the best we can. Okay. Any other questions on that? All right, so then I have two electronic acts. And let me tell you what they are. One is an Electronic Wills Act, and one is an Electronic Estate Planning Documents Act. And you being intelligent people, you're going to say, well, that kind of sounds duplicative to me. Yeah, that'd be a thought. But it's not duplicative, actually, oddly enough. Here's the background. Y'all probably know this. We have an old federal statute from 1988 that basically says everything except estate planning acts and a few other exceptions. A state must allow them to be signed electronically. The Electronic Transactions Act. I didn't know anything about that. Yeah, I'm sure y'all do. I didn't know anything about that until I started on these projects. So the Electronic Wills Act fills a very particular need. It says if what I want to do is go online, all online, it's all going to be electronic, all online, I can type up a will and I can sign the will. I can round up witnesses. I can have a notary. It can all be electronic. Never have to print it out until I get ready to file it with the probate court when I die. And that all works. It's just like a will. It doesn't do anything else. It doesn't say that the standards for a will are different. Doesn't do anything else. Australia, of all things, allows you to do emojis by a will. You can list people, Aunt Mabel, and you can put a frowny face. She's not supposed to get anything. Cousin Fred, put a smiley face. I don't know. People in Alaska seem to like that. We could never figure out how that would work, so we said, no, we're not going to do that. Some people came and said, shouldn't we be able to just record my will? I'm driving down the highway and I want to dictate my will into a phone message. I'm like, no, that's a bridge too far. We don't want to be having to listen to phone messages. That's probably most of us who are old enough to remember the Watergate tapes and all those scrambled tapes, frankly. But that's a different topic. We said, no, text, online, that's fine. Because it's all online anyway. We just happen to print it out when it gets signed, right? So that's what the Electronic Wills Act does. There are always questions about this act that you have to talk about with people, and you have to make sure that the probate clerks and all understand, and we have to deal with all that. But no point dealing with all that if you all say we don't have time to deal with it, to think about that.
How many states have adopted this?
Electronic wills is, I think, north of 25 or so. It's a good number.
Okay.
It's a good number. Okay, so the other one is we discovered after we did electronic wills. We're not perfect legislators, unlike y'all or other people.
Well, I guess just to go back,
Yeah.
You see a lot of companies advertising. Robert Shapiro used to have a company, Legal Zoom, I think it
Right.
was, that you could do all of this,
Right.
wills and so forth. Is that
That's
in those
part
25
that's part
states
of it.
where
Yeah,
it's part of it?
that's part of it. As a matter of fact, this effort originated long before we did it. It originated in Florida, where it didn't go anywhere, by LegalZoom or some other company that basically wanted to have the state bless a particular method for doing one that miraculously would have fit its business model. No, we didn't do that. We just said you can do electronic wills. Then we discovered after we did it, I'm sure this never happens to y'all, but that we had just left a hole in the system because somebody asked us the question, can I electronically sign, DocuSign, my power of attorney or my healthcare surrogate? And we all of us who are uniform law commissioners and who kind of do probate work and trust work, estate planning work, we all knew what the answer was, but we all knew a different answer. About half of us said, well, power of attorney and a healthcare power, those are all estate planning documents, and they would be exempt. They would be exempt under the Electronic Transactions Act. And so, no, you got to do that by hand because we don't have the Uniform Law Commission. No state has an Electronic Power of Attorney Act. At least they didn't then. And the other half of the people said, oh, yeah, no, those are all estate planning acts. And so we said, oh, well, now we've managed to gin up confusion. Nice work, guys. Whereupon we created, the happy part about this is it'd be like the shortest act you probably pass this year. We said, look, you're going to, other acts, and it's not very many. It's powers of attorney, healthcare powers of attorney. It doesn't, you can make it broader, but it doesn't include deeds. It doesn't include, divorce decrees, something like that. Those can be done electronically as well, just because we had created this hole. So I don't think it's controversial at all. Honestly, it'd be kind of odd to do it and not do electronic wills, but anyway, you can do whatever. So, the last one is not a uniform act. And I bring it because y'all have approved something like this before, and so I'm circling back to it. This is a what goes by the name of a Domestic Asset Protection Trust Act, DAPT, if you wanted to Google it sometime. y'all did an act like this, approved an act like this last year. Passed the House, passed the Senate. It originated with Representative Lockett in the House. I've talked to Representative Lockett about this, and he likes all these things, and he's going to try to put them together, and he's excited about it. I went over and I talked to him about this Asset Protection Act. The one that was done the last time around, kind of late in the game, there were some language that probably would have worked, but a court could have really gotten it fouled up and created some real problems. So it disappeared. By which I mean the governor vetoed it, and y'all did not override the veto. But everybody was excited about the concept of the asset protection piece. So we came back. This was a product of that Kentucky Bar Association committee that I mentioned a few minutes ago, back before the pandemic and before that committee disappeared. It is modeled directly on an act that's been around for a long time in Tennessee. And here's what it does. It says I can create a trust, and I can be a beneficiary of the trust, and my creditors cannot reach the assets of the trust unless, number one, I'm already the subject of a lawsuit and we're violating the Voidable Transfers Act, which, as you probably know, Kentucky was the first state to adopt the Voidable Transfers Act. So you can't do that. And if you are a creditor that we place a lot of credibility on, or whatever we want to protect, then those creditors can still reach the assets. So if I put assets in a trust to try to avoid my child support obligations, my obligations to a former spouse, my obligations on a judgment, a court judgment, tort creditor, that sort of thing, they can all still go in. We're not trying to avoid those. Now, you might say, well, Mr. Berry, what creditors are you going to avoid? If tort creditors can get the assets, and if you're no family law, you're not doing anything there. And really the answer here is that these domestic asset protection trusts are not, despite their name, their real purpose is not so much asset protection as it is more like directed trust and trust decanting. If I put assets in a trust and I'm a beneficiary, the Internal Revenue Code says that if my creditors can get those assets are back in my estate, which is maybe good, maybe bad, but is mostly bad. So if, on the other hand, that's not the case, then I can create trusts and I can be a beneficiary, and that's good. Our surrounding states all allow that, and that turns out to be something that folks want to be able to do. So that's why we are, and I couldn't tell you exactly, I'm going to say pretty close to 30, 35 states in one form or another have these kinds of trusts in one form or another. Nevada is the leader in the sense that the nice people in Nevada are perfectly happy with me putting money in a trust and trying to cheat child support, not have that protected, not have my spouse protected. To the rest of us, we think that's kind of weird. We don't quite understand what their thinking is there, but they're in Nevada. That's what they want to do. They hope that a lot of wealthy Californians with a lot of debts will drive across, fly across, whatever, the border and create these trusts. And I think they have done that based on the numbers that you see. Go figure. Anyway, I don't have, as I said before, many Kentuckians that are all that excited about going to Nevada. But Tennessee, sure. Ohio, sure. Don't mind. They don't mind doing that. And so this would be an equalization piece there. And I toss it again, just because y'all vetted that kind of proposal last year, and it passed. I don't think it turned out to be very controversial until, again, there was some unfortunate language that I don't think anybody noticed until it got to be kind of far along. So there we are.
What was the reason for the veto? I don't remember, so that's why I'm asking.
Yes, there were some questions about whether the creditors that I mentioned were really protected. I think that was the intent, but if you actually kind of read through it, you could make a pretty good argument that maybe we hadn't quite captured that. As you all know, it is, and as I've learned in my 20 years with the ULC people, I don't know what there is that's more difficult than actually drafting a piece of legislation that says what you mean and means what you say. I mean, it's easy to foul it up. So that's why it's nice to have a bunch of people have looked at it. So, which is what we got here.
Thank you very much. Does anybody have any questions or comments?
Daniel.
Representative Nemus.
Mr. Berry, I don't know if congratulate you or maybe condemn you for, I've been here for 8 years and I've never had to talk about the rule against perpetuities. So that's come up today.
We got rid of the rule against perpetuities, by the way. We have we call it something else now, but it's the same notion. You can't do trust forever. Right?
It still engenders fright among a lot of the lawyers.
No, me too.
That's right. So with regard to the wills, does an electronic signature, an allowance, bring about more challenges to wills? Are they harder to verify? I assume they still have to have two witnesses, but will the witnesses also be able to sign electronically? Do the witnesses have to be present to see Grandpa sign over everything to his new girlfriend? What's going on? That was a question when we started. That was a real concern when we started. So the answer there is that you can do it all electronically, but everybody's got to be able to see and hear each other, and you got to have a notary who can see and hear the other folks. And then you had the concern about am I there, and is somebody holding a shotgun over here in the corner? There have not been to date any issues with that. I'll point out as well that, and y'all probably know this, on the last day of the session in 2020, y'all you created something that almost every other state adopted. I don't know if you know this, which said, because of the pandemic, that whenever we had something that required an in-person signature in Kentucky, like witnesses and a notary and all together, that if you were in person online and you could hear and you could see, that counted. And that saved us in the pandemic. And I remember immediately I sent that off to friends in a state planning group, and they sent it to New York, which picked it up within a week. So that was an amazing thing. Side note, not in front of you, I love that. Every lawyer I know loves that. Maybe that means it's a bad idea, but love that. If that ever came up again, you would get a lot of enthusiasm for that particular notion, because it is super helpful for lots of people instead of having to drive to an office or take witnesses someplace. But in this case, back to your question, there have not been lawsuits in a lot of instances about that, about the Grandpa. And I think the reason is, if you look at the case law, quite frankly, if Grandpa is going to leave money to the caregiver or to the whatever, the caregiver, God bless her, doesn't have much trouble rounding up a lawyer who will do it and rounding up a couple of witnesses from his office who will all come over to the house, and they'll just have a big time. And so it's an inverse. It is that's a problem. The whole elder law thing, that's a problem, as we know, and this doesn't solve the problem, but it doesn't make it any worse. Thank you, Mr. Chairman.
Thank you. And I think you had mentioned the shotgun in the corner. That would be undue influence, I think, wouldn't it?
It would be. It seems to me it would be. You're exactly right.
Well, thank you for your presentation. We appreciate it.
Thank you. Thank you very much. Appreciate your attention to all this.
So our next presentation is Medicaid in the prison population. And we have several guests, and they would come forward and introduce themselves, and then you may proceed.
Good afternoon, Chair Elliott. Leslie Hoffman, Deputy Commissioner for the Department of Medicaid Services.
Angela Sparrow, Behavioral Health Supervisor, Department for Medicaid Services.
Beth Moore, Director of Public Affairs, Department of Corrections.
Elsie Berger, the Executive Director for the Office of Support Services for the Department of Juvenile Justice.
Chair Elliott, first of all, thank you for allowing us the opportunity today to come in and talk about one of our passions. We have many, but this is definitely one that we've been working on for quite some time, and happy to come speak today. So Kentucky has a wonderful opportunity to improve health care for incarcerated individuals and juvenile offenders. There are many challenges and needs still that we have to address in Kentucky. Incarcerated individuals and juvenile offenders face disproportionate challenges and barriers upon reentry to society, and therefore they are at higher risk for injury and death, higher than the general public. Kentucky continues to make strides in reducing incarceration rates and challenges that our reentry population face to ensure prosperous communities across our Commonwealth of Kentucky. CMS, the Center for Medicare and Medicaid Services, CMS, which is our federal authority, released guidance on April the 17th of 2023. CMS issued a state Medicaid director letter, which we call 23003, regarding opportunities to test transition-related strategies to support community reentry and improve care transitions for individuals who are incarcerated. It's a long title, but it's an opportunity that CMS put out, and they usually tag those by specific show letter numbers, so that's why it's 23003. This was the first opportunity of its kind to allow state Medicaid agencies across the nation to reimburse for targeted services pre-release. This project will enhance and streamline the reentry processes by improving care coordination through systematic collaboration and ensuring continuity of care, while linking justice-involved individuals to medical and behavioral health services upon their release. What benefits might we see from this, you may ask? Successful reentry into the community will promote better health outcomes to help reduce recidivism across the Commonwealth. This provides for a better quality of life, and I think we can all agree in this room that we do hope that our Kentucky members are successful, have a better quality of life, and are contributors to our community. So we're going to talk a little bit about Kentucky's program approval. Early this year, CMS announced a new approach utilizing an expedited bundle approach for reviewing and approving multiple states' 1115 reentry opportunity applications that were pending. On July the 2nd of 2024, this year, the Center for Medicaid and Medicare Services approved Kentucky's Department for Medicaid 1115 reentry application. Although DMS received the approval, this is much, much more. The reentry project is a Kentucky implementation across the state. The Department for Medicaid Services and the Cabinet for Health and Family Services value our partnerships with the opportunity to collectively implement this program across the Commonwealth. Our partners are imperative for the success of this program across Kentucky. Kentucky's application was approved alongside Illinois', Oregon, Utah, and Vermont in the first expedited bundle of states. CMS organized these bundles based on a combination of different things, whether the reentry was part of a larger application that the state may have, when our current flexibilities may be pending approval or ending. One caveat to this expedited process was that the states were required to have a pending application, and it must align with the show letter that I told you about earlier, which was the 23003, and that we would not be modifying during this process. Those states that did not meet the expedited path process or decided to just opt out at the time would take the regular review process, which would be much at a later date in 2025. So we chose to stay right where we were in line for the expedited process. The reentry project is aimed at improving care transitions for incarcerated individuals and juvenile offenders. Some key program components for the Reentry 1115. Let's go over those. The Reentry Project offers a unique opportunity for Kentucky to improve health outcomes and to support successful reintegration for our individuals transitioning back to our communities in the Commonwealth of Kentucky. It allows state Medicaid agencies to provide targeted, short-term, pre-release benefit package. All participating facilities in Kentucky are required to complete a readiness assessment prior to implementation per CMS's guidelines. The readiness assessment is to ensure that all correctional facilities can successfully implement the project, which includes supporting Medicaid screening and application process, providing and facilitating the benefit package at the appropriate pre-release time frame, and supporting data exchange required for these reentry activities. What are our reentry goals? And they've pretty much remained very consistent along the way. We want to improve access to services. We want to improve coordination and communication. We want to reduce the number of avoidable emergency department visits and inpatient hospitalizations, and increase additional investments in healthcare and related services to improve the quality of our individuals in incarcerated settings pre- and post-release into the community. Kentucky plans to implement an integrated and synthesized approach to implement the project, incorporating feedback from individuals with lived experience to inform our program development. We plan to ensure that Medicaid eligible individuals at a participating facility but not yet enrolled in Medicaid are afforded the opportunity to apply for Kentucky Medicaid. Individuals will also be educated about the reentry services and supports. Kentucky will establish protocols and support individuals' person-centered plans specific for reentry needs, and to empower the individuals to make decisions relative to their own health and behavioral health needs and social needs. Case managers will also have knowledge of community-based providers, support for the development of a holistic care approach utilizing comprehensive assessment tools. Kentucky will ensure and support the collaboration, and we will plan to develop a secure and interoperable data exchange platform, which is very important for us, that enables a seamless transfer of health information between healthcare systems, our correctional systems, our state agencies, and our community partners. Kentucky's eligibility and covered services. In the guidance that was sent out to states from CMS, they made it very clear to us that these projects were not intended to supplant any of the work that our correctional partners are already completing and doing. But we are to foster collaboration and communication among the healthcare systems, our judicial systems, and our communities, needed to ensure the continuity of care and support throughout the transition process. The project places an emphasis on healthcare data exchange, which is a vital role in supporting the justice-involved population and ensuring access to data that is permitted to be shared between our judicial systems, our healthcare systems, and our community providers. What populations are covered? For this reentry opportunity, all adults in the state prisons and all youth that are in youth development centers or YDCs. What are the covered services that are included? Case management is included to address physical health, behavioral health, and health-related social needs, HRSN, upon 60 days prior to release and up to 12 months post-release by the MCOs, managed care organizations here in Kentucky. Health-related social needs, for example, can include housing and employment, food, and transportation, and that's just a few of the items it can include. Needs will be identified through a comprehensive assessment and develop an individualized care management plan based on the assessment to address the identified needs to be carried out upon the individual's release. The case manager will refer and coordinate all activities and resources pre-release to ensure a smooth transition back to our communities and provide the necessary supports through continuing case management services up to 12 months post-release. This is to ensure that the plan is effectively implementing and the needs are adequately being met and addressed. Medication-assisted treatment, or MAT, M-A-T, which includes medication and accompanying therapies or counseling services for individuals that are diagnosed with SUD, substance use disorder, up to 60 days prior to release. Also, a 30-day supply of all medication during release will also include physical health, behavioral health, and any over-the-counter medications that are clinically appropriate for that individual. Remember that this initial approval and benefit package allows for Kentucky to build upon an existing infrastructure to build that solid block or foundation to support future amendments and expansion of the program. So we want to ensure that when we get started, let's start right and that we have a solid foundation to build that house upon. And I'm going to turn it over to Angela Sparrow.
Next slide, please. We want to touch a little bit on the budget neutrality and, again, fiscal impacts regarding the program. So again, projects must be budget neutral, and this is a prerequisite for approval under the Center for Medicare and Medicaid Services for all states. And so this means, again, that Medicaid expenditures must not exceed the spending as it would without the demonstration or the project in place. So the cost of the services must be less than or equal to the cost of the services provided today. And so again, we determine budget neutrality and what those cost of services are, if you will, through service expenditure limits, and we utilize a blended per member, what we term as per member per month. So the PMPM of expected costs for the reentry services provided under the project, and that's using a combination of Medicaid rates, historical cost of services, and again, comparable service rates of the services that would be provided under the project. So with the approval, again, of the demonstration, again, we were able to demonstrate to CMS that the project, again, will be budget neutral, and we'll continue to monitor that throughout the implementation and report that. In addition to the budget neutrality, and again, what is new under this project and opportunity is for the non-serviced expenditure limits. So there is an opportunity new to the reentry project that the state, again, can receive a federal match for non-services expenditures. And so, again, we had been awarded and approved for over $5 million to be utilized over the course of the implementation. And again, this is to support implementation of the project, not only for Medicaid, but for our state partners, for our community partners as well. So again, these are this is to support the non-service expenditure component of implementing the demonstration. Next slide, please. In addition to the budget neutrality component of the project, the state, new to the reentry project, again, the states are required under CMS guidance to also include a reinvestment plan. And so CMS, again, Center for Medicare and Medicaid Services, has informed states under these projects, again, they will not approve the federal match for existing carceral health care services that are currently being provided today in the correctional facilities unless the state agrees to reinvest that federal match within the reentry program. So what that means, again, the state has an opportunity to utilize that federal match and reinvest that into new or enhanced or expand pre-release services for the demonstration for the project population, to improve health information technology and data sharing needed to be able to provide services to the individuals, and again, support that collaboration among correctional partners and state agencies, and again, can also expand and enhance community-based reentry services and supports for that individual at the time that they are released. States must submit, again, the reinvestment plan as to how they will reinvest the federal match for the existing services to CMS as a part of the requirements for the project as well. Medicaid, again, has determined that only the 30-day supply of medications will qualify as that existing service. And we do estimate, again, that little over $11 million would be reinvested as a part of that. As a part of the project over the course of the demonstration. And so the new expenditures for reentry services covered under the reentry project will also count towards the reinvested amount. Next slide, please. So we also, in in addition to the reentry project, there is additional services that we do want to talk about as well that Medicaid will be covering for our youth. So there are new provisions of Medicaid services, and in the 2023 Consolidations Appropriations Act, the CAA, Congress did include a couple of sections, and that would be Section 5121 and Section 5122, and it does amend existing laws that formally limit Medicaid and CHIP coverage for our youth in incarcerated settings. And so, again, Section 5121 is mandatory of states. And again, this would allow for coverage for selected Medicaid services pre-release, and Section 5122 is optional of states. And so, again, this is in addition to the reentry project that Leslie reviewed. And so in July, again, CMS did release guidance to states for the required section and optional section provisions, and these are to take effect. The mandatory, again, is to take effect January 1st of 2025. So we have been working with our correctional and our justice partners along with this initiative, and really incorporating that into the reentry project planning that we've spoke to. States must submit their Medicaid and CHIP state plan amendments. So again, these will be state plan services to CMS by March 31st of 2025. But again, is required to have a January 1st, 2025 effective date. Next slide, please. So we'll talk a little bit about what are the sections and the requirements. So in terms of Section 5121, again, the mandatory section, for the eligible population, it is, again, for the adjudicated juveniles under the age of 21 years of age. And so adjudicated, again, would mean that they have received a disposition. And so, again, that would be for those individuals that are under the age of 21, or, again, we are also including the adjudicated individuals that are between the ages of 18 and 26 that are formally in foster care. So the covered services that the state, again, is to required to cover is early and periodic screening, diagnostic, and treatment services, or EPSDT services. And so EPSDT services does include medical, dental, and behavioral health screenings and diagnostic services, in addition to targeted case management services. And so these services, again, are to be provided 30 days pre-release. And then for the targeted case management, it would be, again, provided at least 30 days post-release. And so when we think about the eligible population and how it's defined under these sections, we, again, do have a variety of carceral settings in which these individuals could be potentially in, and that would include our youth development centers, our youth detention centers, our state prisons, and local jails. Next slide, please. So regarding Section 5122, the optional, again, when we think of the eligible population, the same definition applies. We are looking, except for we are looking at pre-adjudicated juveniles under the age of 21, and again, the pre-adjudicated juveniles between the ages of 18 and 26 that are in former foster care. At this, again, under this section, the Medicaid eligibility for that individual is not suspended, and so that is new. Typically, again, when an individual is placed in a carceral setting, their Medicaid eligibility is suspended. So this is new. It would not be suspended. And then again, those individuals, that eligible juvenile, would be entitled to their benefits that are covered under their Medicaid service package. So under this section 5122, again, this does allow the state to request that full range of Medicaid and CHIP services to the individual that would be eligible for that Medicaid coverage. And again, the settings would be the same as the section 5121, which includes our youth development centers, our youth detention centers, our state prisons, and local jails.
community partner collaboration. If any of you all have heard me speak before, I continue to be amazed at the level of integration and collaboration that we have across the state with many efforts, not just this particular project. We are definitely knocking down barriers and trying to enhance the lives of all Kentuckians. So we're proud of the work that we've done in our communities and with our sister agencies. This diagram is the program governance and project oversight. As I said before, Kentucky is very pleased with the lots of things that we have developed, including this one, which is our part of our Kentucky ACRES, ACRES, which stands for Kentucky's Advisory and Community Collaboration for Reentry Services. Medicaid likes our acronyms and our numbers. This slide demonstrates the governance and the project oversight, including Kentucky ACRES, the core project team, work streams, and the Medicaid project team. The role of Kentucky ACRES is to provide executive-level oversight and strategic direction for the project team, ensuring alignment of a broader reentry goal and objectives for all of Kentucky. The role of the core project team is focused on implementing task and project needs, supporting policy development, and strategy execution. Executing strategies according to policy and providing direct oversight of the work project streams. Establishing this reentry process has been essential for the success, as we are all working collaboratively together in the Commonwealth of Kentucky to identify challenges and barriers and coming up with solutions together for all justice-involved individuals. Our advisory work group, as you can see here, ACRES contains representation from many folks. Kentucky recognizes the importance of establishing and maintaining our partnerships to ensure the successful integration for incarcerated individuals and juvenile offenders returning to the community. As you can see, ACRES is comprised of many subject matter experts from across our state. They will help us to inform, design, and implement the program. NASHB and HARP Reentry Learning Collaborative, the National Academy for State Health Policy is NASHB, and the Health and Reentry Project is HARP. And we were selected with 6 other states, so 7 states, to participate in an 18-month learning collaborative to support states with strategies to improve the individuals transitioning from incarceration to the community. States will receive peer-to-peer state network and targeted technical assistance. So each one of these states had to meet some criteria. We had to have either approved and or pending applications, and we worked together because we're all in different phases. So we all kind of work together about best practices and where each state is in their progress towards implementation. The collaborative kickoff was in June, including leadership from the Department of Medicaid, the Department for Behavioral Health, Developmental, and Intellectual Disabilities, the Office of Drug Control Policy, the Department of Corrections, and the Department of Juvenile Justice. Again, as many of you may have heard me say before, in my 27 years with state government and Medicaid programs, I have never been prouder to stand with my colleagues across the state at a commissioner level representation in Washington, D.C., all working towards one common goal, and that was reentry. I definitely feel like we were Team Kentucky that day. Sorry, I'm going to turn it over. No, this is mine too. And I will now be going over the project timeline. So the reentry project timeline, as you may have heard Angela mention earlier about timelines to get things started. Just as a reminder, I wanted to tell everybody the complexities of the 1115 program, and we want to share this timeline with you for Kentucky's implementation. As I've mentioned before, the 1115 was approved July of the 2nd of this year. However, it cannot go live until many requirements are completed and approved by the Center for Medicare and Medicaid Services before we can actually move forward. So you can see our timeline here. On October the 30th, our implementation plan must be drafted and submitted to CMS for approval. We have completed many stakeholder engagements to support the mapping of the state's current environment and for to identify needs and gaps. We have included many focus groups. Have done interviews. We've completed lots of data requests, work sessions with individuals with lived experience, behavioral health provider interviews and meetings, primary care providers, other state agencies, including the Department for Public Health, the Administrative Office of the Courts, the Department of Aging and Independent Living, Department of Community-Based Services, Department of Behavioral Health Services, and our MCOs, managed care organizations, here in Kentucky. Following the implementation plan, as you can see, it's a continuation on a timeline for quite some time. After the implementation plan is submitted, monitoring protocols have to be submitted by November the 29th. The reinvestment plan and the evaluation plan are due by December the 29th. And we are also required to obtain an independent evaluator for all of our 1115 projects, which is a neutral party that assesses our projects and then develops reports to send back to CMS. January the 1st of 2025, as Angela mentioned, new youth Medicaid provisions will be effective, and then we are looking for sometime between summer and the fall of 2025 implementation upon CMS's approval. I will let you know that we can push CMS, but we cannot always know exactly their deadlines and how long they're going to take for things. Questions? This is our DMS home site, our DMS behavioral health issues box. You can click on those, and or there's my email address, and we are always happy to answer any questions that we have about this project.
So thank you for your discussion. We appreciate it. I did have a question on 1522, which is optional. Is DMS planning to request the full range of Medicaid and CHIP services?
Yes, again, we do plan to request the optional. Again, with the optional, we can opt in at any time after January 1st. So if we do not request on January 1st, we can still request at any point in time. So again, we do plan to do so. We are working with our justice partners in planning and really, again, still looking at what our current state, identifying those gaps in terms of how to implement that section. And so again, the exact timeline is still to be determined at when we could request that.
Thank you. Senator Wheeler.
Thank you, Mr. Chairman. And, I anxiously listed this program, but it was a little bit confusing to me exactly who's covered and who's not, although I did kind of notice one fairly glaring omission in the sense that folks housed in county jails will not be covered, and that's been a subject that myself and Senator Storm and I think Representative Meredith and others have been looking at over the last several sessions. That generally the largest cost for any rural county government is the maintenance of the county jail, and a very large portion of that is in fact the health care costs associated with managing the county jail. To what degree have you all advocated or inquired about the use of this program for inmates that are actually housed on a county level? Because I could see where this would be a good tool to maybe alleviate some of those costs that are straining our rural counties.
Absolutely. And we agree as well. And so again, we really building, as we talked in terms of the requirements, like you mentioned, it is very complex. It's a very complex project. So again, there are many things that we need to be able to demonstrate to CMS for approval in terms of if we think of the infrastructure, there are nearly 80 jails across Kentucky that do operate differently. We do have to be able to ensure that the facility has access, can provide those services, and then again also screen and support Medicaid screening eligibility, identify who's eligible for services. There's lots of nuances, if you will. So we absolutely do agree and do want to onboard the jails. We are building the infrastructure to support that through this initial implementation. So in terms of health data exchanges, system changes, the things again that we need to do to support onboarding them, we absolutely want to do that. So again, we can amend at any time. We did need to, in order just to begin our initial implementation and not delay any farther. Needed to really stick with our what was in the initial application to stay within that first cohort. So we can amend and hope to amend to certainly do that. We are engaging and will be engaging with the jails to discuss on how to onboard and what it could look like for them, what this project could look like for them, and identify what those needs are. But they will be included in the CAA, the Section 5121, and so really that is also the opportunity to start providing services and engaging and getting them on board.
And I guess one other issue I had, I noticed that you said medication-assisted treatment for counseling with individuals with a substance abuse disorder up to 60 days prior to the release. I mean, frankly, one of the most common street drugs you see in eastern Kentucky right now is Suboxone from people going to medication-assisted treatment. I mean, once we get these people kind of in jail and incarcerated and detoxed, why do we really want to start them back up on something that they're addicted to, that they might essentially put them into a community where they're dealing this stuff while, but right before we get them ready to put back out on the street? And
I believe I'm going to look back at Angela too. That was a required service that CMS required of us.
You got to be kidding me.
No, sir.
That's pathetic. Anyway, by the way, I was supposed to do this earlier, Mr. Chair. If you
go ahead.
While we're on the subject of counties, I have the honor of the new president of the County Attorneys Association, Joe Ross, that came to visit me beforehand from Logan County, sitting back here. We had some good acquaintances from Logan County and the Orange family, so wonderful guy. We're glad to have him here today as our guest at the Judiciary Committee, so thank you, Mr. Chairman.
Thank you, and I don't think I provided members with that option, and he and I met yesterday and had a good discussion, so thank you for doing that. We have about, let's see, how many is that, 7? 7 members who have requested time to ask questions, so if we could move expeditiously, Senator Berg.
Thank you for a very, very interesting presentation. I just want to clarify that I'm understanding a few things correctly. When a person in this state, an adult, becomes incarcerated in this state, they lose their Medicare and Medicaid eligibility?
They don't lose. It is suspended. So Kentucky is one of the states. We do not terminate their Medicaid eligibility. So it is suspended until the time that they are released.
So a follow-up, the services we provide to them while they are incarcerated, we are not allowed to bill Medicare or Medicaid for? The state picks up the cost of those services?
That's correct.
Whoa.
That is up until this opportunity from CMS and from Congress. Medicaid has not had the authority or the ability to cover services while that individual is.
So as soon as we put somebody in one of our facilities, we as a state become responsible for covering the costs of their health care. And this would allow us, if we choose the optional for children, then all services would be covered while they are in our purview, and for adults only screening and diagnostics, or would we actually extend therapeutic coverage as well for adults?
For the adults, again, they would fall under the reentry. They would be eligible for selected services at the selected time period. Again, they were clear to state that they were staying to that selected time period pre-release, really to support that re-engagement, transitional, build that, identify what are those community needs, build that plan, and again, be able to make those referrals, those connections to support at the time that they are released.
All right, I think I understand what you're trying to do, and thank you very, very much, because I mean, honestly, if these are services that can and should be covered, oh my God, that would be in our financial interest to do that so seriously. And then do we direct bill, or how? What's the reimbursement process?
We again are proposing that the managed care organizations would be providing case management services to that individual pre and post release. So they'll be following them, be eligible to follow them up to 12 months for this targeted population. They will still be following if there's other needs, but again, really this targeted case management support up to 12 months post release. Again, we're looking at proposing that our correctional and our justice partners, DOC, DJJ, will actually be able to enroll as a provider, bill for the services, so they would be receiving that reimbursement to support providing that service to that individual.
Thank you.
Thank you. I'm reminded of my time as co-chair of the Medicaid Oversight Advisory Council, which no longer exists. I think I'm back in one of those meetings, so, and I'm not, thank goodness. Senator Carroll.
Thank you, Mr. Chairman, and thank you all for the presentation. Help me understand, when you were talking about the county jails differentiating state inmates held in the county jail, are we looking to expand this to county inmates also?
Under the initial approval, it will only be for the adults inmates. in the state prisons. Okay. So
post adjudication.
Correct.
Okay. But with the opportunity to expand to county inmates, correct?
Yes.
Okay.
Yes.
Okay. And then the other question, under the 5111 and or 5121, 5122, there was a lot of discussion last session about the mental health juvenile detention facility, and I know there were conversations about the ability maybe coming to be able to provide those services and be covered through Medicaid. And I'm assuming this is what Secretary Friedlander was referring to during those conversations. And I know that there was concern about this facility, which up until South Carolina got ahead of us, would have been the first of its kind. So if we build this facility, the mental health services that would be provided within that facility, because it would not be at a YDC, it would be a separate new type of facility for mental health treatment. I'm assuming that under this, that those services would be provided and would be able to be provided under Medicaid, correct?
Under Section 5121, the mandatory section, if the juvenile, again, falls in that definition of adjudicated and in that age range, it would apply for any of those settings that individual would be placed in. So if that is true, it would be a covered setting.
Okay.
Under the reentry project, with the additional services, the services up to 60 days pre-release, we would have to make an amendment and a request to CMS to add any additional facilities beyond the YDCs and the state prisons to do that.
All right, very good. Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator. So we have 6 members. I'm going to ask you to keep it to a minute apiece, if possible. Representative Moser.
Thank you, Mr. Chairman. A minute. I've been working on this for 8 years, so I couldn't be happier that this has been approved. It's been a long journey, lots of different application, scenarios, and some of my questions have been answered. But do we know that we have all the resources and the staff in our 12 state prisons to carry this out? And I know that we're working on certifying different communities as recovery ready and building this ecosystem. Do we have the resources that we need and the partnerships to refer out for additional treatment and follow-up?
That's a great question. I think, again, that's part of the planning process that's being built in, part of the assessments. We are wrapping up our current state assessments and gap analysis as early as this week and next week to really, but short answer, yes, there are some staffing needs. Again, that's through the planning process. We will plan on how to address those needs to be able to support the implementation. Adding new services, new process, again, those right. things will be in line. That is part of what we'll demonstrate to CMS on how we've identified those things and how we will address those things.
Perfect. Okay. And then a quick follow-up about the substance use treatment, medication for addiction treatment. I assume then that anyone who is prescribed buprenorphine or another longer-acting or injectable non-divertible substance is going to be referred to follow-up and reentry in that case management. Okay. Yeah.
Yes.
Thank you.
Thank you, Representative Kulkarni.
Thank you, Mr. Chair. I have two quick questions, and they have to do with the services that are covered. So my first question is, do you see or have you seen any trend or prevalence of certain conditions specific to this population that you're expanding covered services for? And what is the relative cost, like proportionate cost breakdown of those to the other services that are covered? And you get that information to me, after the fact if needed. I just was curious about that. And then my second question is probably related to the answer that you gave to Representative Moser, specifically to behavioral and mental health services that are going to be offered, which is great. My question is, how are you anticipating the provider shortage? What are you going to do about that, especially as I'm expecting that particular, those services are going to be needed as well. So I wanted, and maybe it's coming into this planning analysis, but I was curious about how you're specifically addressing that shortage.
I think in terms of specific numbers, we could follow up with you. I think, again, like you mentioned, in terms of needs identified, there are behavioral health needs within this population, certainly, as well as others, and the social needs. And that, again, is a large component of that case management service, is also addressing the social needs in addition to our physical and behavioral health needs. In terms of specific numbers of current, we can, I think, follow up with that in the cost. Again, we can share the cost projections under the demonstration project for the next 5 years in terms of current costs. We can follow up with that. For the second question in terms of addressing provider shortages, that we know provider shortages. With that being said, I think our community partners are very eager to support this project and to support this population, and really, again, be a part of building the data sharing, those connections, and again, ensuring that we have those resources. So I think the support is certainly there. Also, just looking at the DOC, DJJ, and the provider that is currently providing medical services and their capacity to provide the services pre-release, and again, just be reimbursed from Medicaid for those services. So we feel, again, that they have that capacity. We are working with DOC to expand in terms of the medication-assisted treatment service. We know, again, that there is access to that service in the state prisons. We will need to expand forms of medications that are available in all of the prisons. And so, again, looking at the staffing and options for them to do that. But that is, again, part of the implementation planning process.
Thank you. So we have two more questioners, and I want to give County Attorney Tapke time to present on our last topic this morning on guardianship law. So Representative Herron is recognized.
Thank you, Mr. Chair, and thank you all for this presentation. I first heard about this at NCSL, so it's exciting to hear. And I think that we as a state should be proud that we are one of 7 states to be a part of this, and the only state in the South. And so I am very excited about the possibilities and the partnerships. And I know it's a lot. And some of my questions have been answered already, but I do want to just get some clarification around the juvenile population. So will they only be receiving those case management services just 30 days after, or is it 12 months?
For the Section 5121 initially effective 1/1/25, again, it would be the 30 days. Many of the 30 days post-release, many of our managed care organizations have case management management programs to support those individuals. Most of them, again, will be eligible for our Aetna Sky program, again, and that does provide that ongoing case management. So, again, we're confident that there will be the support there to support them ongoing if they need that beyond the 30 days. When, again, the reentry project goes live in summer to fall of next year, the case management services for the YDCs will begin 60 days, and that's where they'll have that 12-month, up to 12-month. So it's in when that comes into place, yes, there'll be up to 12 months of case management services.
Thank you. Mr. Chair, I have one more question.
I'm sorry, we have at 1 o'clock, there's another committee meeting, so I've said expeditiously 1 minute, et cetera.
We need to do better about which issues are more important. I think that this is an issue that is super important. And for us not to be able to fully discuss it is very frustrating.
We've had a long discussion here. I don't know if we can look at how long we've been discussing it if you want to look at the time. And I'm fine to do that. Representative Flannery, you're recognized. Thank you. I appreciate that. So thank you very much for your presentation this morning. We do appreciate it. The next topic is Guardianship Law. If County Attorney Tapke would come forward.
Sure, I'm live there. Is this me? Okay. Good afternoon, Chairman Elliott and members of the Judiciary. Thank you for having me here today. My name is Stacy Tapke, and I'm the Kenton County Attorney. And since about 2007, I've handled all the guardianship matters for Kenton County. So to say I've probably done hundreds of them would be accurate. So when I think I've seen them all, one comes that I haven't seen before, but I have a great deal of experience in the different types of guardianship. And just note, we throw the terms loosely around guardianship, disability. I'll try to go over that, but if I start using those terms interchangeably, forgive me in advance. Just kind of a 101 as a reminder of what guardianships are. When somebody's unable to make informed decisions as to their personal affairs or financial resources, families have to look to the court system. This is usually when someone doesn't have powers of attorney or healthcare surrogates in place. And the family has to file a petition for disability, and the court will have a hearing in district court deciding whether or not that individual needs a guardian to manage their personal decisions and or a conservator to manage their financial affairs. And prior to this hearing, the person will be assessed by 3 professionals. There's a medical doctor or qualifying medical professional. There is a psychologist, and also finally a social worker, typically someone from the Cabinet for Health and Family Services. The county attorney is responsible for presenting the evidence to the judge, the district judge, and the person can either have a bench trial or a jury trial. And If they are found to lack capacity, then they will be declared either fully disabled, that means they can't make any decisions, or partially disabled, which means they have some rights and others they do not. And then the guardian or conservator will be appointed. These are the most common types of guardianships we see. I keep my own statistics, so this is pretty in line with, I think, the state too. The first, of course, is someone with diminished capacity due to a disease like Alzheimer's or dementia, who again didn't plan in advance with those healthcare surrogates or powers of attorney. The second most common that I usually see is a child who's turning 18, and they're going to need their parent to take care of them. It's someone with an intellectual or developmental delay. Most often I'm seeing autism diagnoses that are needing the guardianship. Third, and increasing in number and about maybe to eclipse in Kenton County the children, is those who are so severely mentally ill that they now lack the ability to even meet their most basic needs. They can't even get housing for themselves. They can't do anything that really needs the most basic health and safety. And then those most often what I'm seeing is a diagnosis of paranoid schizophrenia. And then, of course, a traumatic event like a car accident where someone's probably young and just didn't think to do those estate planning, and they need an immediate guardian. This is a list of what we're seeing in Kentucky. I got these numbers thanks to the Administrative Office of the Courts. Appreciate their help with this. What you're seeing is a pretty steady number in the last 3 fiscal years. So we're right around 4,500 a year across all the states. Not surprisingly, the top 3 are your top 3 most populated if you look at the data. I would say if we went back about a decade, we'd probably see a pretty significant leap from what was happening 10 years ago to what's happening now, just as our population continues to age and needs these guardianships. Thank you to the state guardianship team. They provided me with the information about how many people they have under a state guardian, and they broke it down by age. It looks like I failed to give the total number, but it's around 4,500 if my math on the fly is good, but I am a lawyer, so you can never quite trust my math, right? But as you can see, there's mostly looking at people that are, that 50 age and above. Recent legislative changes, I just kind of wanted to go over the big changes to the guardianship statutes over the last few years. Of course, Chairman Elliott, as you are very familiar with, House Bill 5, which was done in 2018. And the major change there was move from having every single one of these cases be heard by a jury to allowing decision to be made by the parties as to whether or not to proceed and have a bench trial. I can tell you that families are very grateful to be able to just try these to the bench. It's very emotional for them, particularly parents, to have to testify, to talk about why their child can't do things. And so they have commented to me just an appreciation of no longer having that requirement. However, if it's needed, if someone wants it, we absolutely will do it. It's their right, because we want to make sure that if someone is wanting to challenge their rights, they're able to do so. 2022, the Jeff Tyler Act, that was not a big change, but it allows emergency guardianships to be filed by private parties and have those heard quickly, and it allows them to have an opportunity to present evidence in addition to the county attorney. Last year, Seth's Law, House Bill 385, Representative Mosier's bill, and the first Mental Health Commission bill. This didn't change Chapter 387, but it did allow the expansion of who is a medical decision maker, which we're hoping will help limit the number of people who have to seek a guardianship or an emergency guardianship going into the future. And I failed to include, and remiss, we also had Senate Bill 74, which we appreciate was a cleanup bill to address a court case that impacted the social worker and how they could testify. So we're very grateful for that change. because that's helped make sure that our cases are going forward. I wanted to just highlight some of the recent efforts around guardianship. I did not participate in the WINGS initiative, but that was an initiative that was, I believe, out of the House and an effort between AOC and some other agencies to look at all of the guardianship statutes and see what needed to be changed, where we could do better. I think it may have just sort of ended due to COVID and funding. But then what happened next was the Administrative Office of the Courts created the Mental Health Commission. And one of the subgroups of the groups is the Guardianship Working Group, of which I am the chair. And so we meet monthly. We have representatives from all parts of the guardianship process. We have state guardianship. We have elder law attorneys. We have people with lived experience. We tried to make sure that anybody who was impacted in any way by this is involved. Open invitation to anybody who wants to participate. We let anyone join our group. And then there's also, I think, from my discussions with some staff at AOC, the national courts are starting to look at this issue. I don't know if it was sort of the Free Britney or the movie on Netflix that kind of brought this issue to the forefront, but it is definitely more discussed. One of the things that came out of that guardianship working group, and thank you to AOC staff for allowing me to utilize this data, we sent out a survey to all of the clerks, the county attorneys, and the judges, asking them a lot of questions to try to glean from them what is the current state of guardianship practice in Kentucky. It can vary from county to county, and we were just trying to get an idea of the results. And one result, for example, is, and we got great participation too, by the way, almost everybody is using a standard that is for the attorney, for the respondent, the person we're seeking guardianship of. Overwhelmingly, the attorney's role is to serve that client's best interest. We also see that for the most part, these petitions are being heard relatively quickly, 60 days or less, which is not bad when you think of all the assessments that have to be completed. And less than 20% of those responding have had a jury trial. I will share that since it was enacted in Kenton County, I haven't had any. No one has requested one, so they definitely prefer that trial to the judge. Finally, I just kind of wanted to give an update on what I see as actions and activities relating to the guardianship world, and some of these have been discussed in that guardianship work group, for example. Several of these were also discussed in the WINGS effort, so what you can kind of see is similar themes that keep coming forward. An example of that would be ward. Everybody agrees that's a very antiquated word to use, and a preference to see that term changed at some point. Things that have happened, legal form changes. They recently launched a disability form for those cases. I just had one yesterday. It was very exciting, where someone actually had their rights returned to them. It was somebody who had to be under a guardianship due to his mental illness, and he has had great progress to the point where he actually got all of his rights restored. Prior to a few weeks ago, there wasn't a form for that. There was just kind of the writing on the docket sheet from the judges. So now we have a form that looks more presentable, that is going to be better for that individual to take everywhere to show that they had their rights restored. We talk and think about ideas like that. Informational materials, what's become apparent is a need for educational materials for those participating in the process in particular. A lot of people don't understand it, so we're all kind of trying to come up with ideas and ways in which we can develop those materials for publication. Educational opportunities, another sort of theme, has been a little bit of difference county by county of how these are conducted, and the opportunity to educate our judges as well as our county attorneys and practicing attorneys in the guardianship world on the laws, the changes, the roles, that sort of thing. We've also talked a great deal about ways in which we can work on alternatives to guardianship, the hope being this is the last resort. We would rather you have executed a power of attorney or a healthcare surrogate in which you said what you want and what your desires are versus everybody trying to guess what those are. So we've been talking about all the different ways in which that's possible, and just a plug of, if you haven't dusted off those decision-making forms, maybe a good opportunity to go and look so that you can designate who you want to make decisions for you in the future should something happen. We've also discussed better data collection. We've discovered that we just really don't know all of the numbers. We don't quite know what kinds of guardianships are we seeing, what's happening to those. We think that there should be at some point probably some better data collection. And then, of course, another theme is just improving oversight and accountability of guardians. We want to make sure that those who have been entrusted with that role over the person are doing it correctly, that they're spending the money for their benefit and not for their own. And that is hopefully a speedy presentation. I stand for any questions that you may have.
I appreciate that very much, and I want to thank you for the work that you've done as chairman of the Guardianship Subcommittee as part of the Mental Health Commission effort. And as you know, when a family is facing guardianship, it's a very difficult situation. So this is a very important aspect of our law. It's not very lucrative. I know you and I were talking about what a respondent's attorney is paid in Kenton County, for instance, if the person is indigent. And of course, the county fiscal court picks up that cost. So in some regards, it is a public service. I wanted to ask you specifically about the disagreement over the role of the respondent's attorney. And as I understand it, some in your group and some in the private bar think that it should be a zealous advocate standard instead of the guardian ad litem system that we have now. Do you have a position on that, and what discussions have you had within your group?
Sure.
And have you reached a consensus on that? And I spoke to Senator Thomas yesterday, and I know he's very passionate about this issue, and he and I had a nice discussion. I know he's been part of your group, and so I thanked him for his efforts to look into this with the legislation that he's had, because this is an area of law where there isn't necessarily a lot of attention. So if you just speak to that, I'd appreciate it.
I'd be happy to, and thank you. Yes, that is and an open invitation for any legislator that wants to jump in and hear our conversation. I know some have taken advantage of that, like Senator Thomas. That is an area in which, unlike the antiquated term ward, this has been more of a healthy discussion. There are some who really feel like the standard for the person representing the respondent, that's the person we're talking about, should be a zealous advocate. They should fight for that person's wishes no matter what, versus a standard where it's really what is in their best interest. You see that with involving children, for example. And what we found, at least from the survey, is I think overwhelmingly the courts in Kentucky, I feel safe saying, we're all using a best interest for the ward standard, or best interest for the respondent standard. But there are definitely some who feel like maybe perhaps you need that zealous advocate. Some people think that there ought to be two, one for both interests. Of course, not only do I represent the Commonwealth in these guardianship cases, I also represent the fiscal court. So I'm very mindful of how quickly costs could increase if you started to have the fiscal court paying for all of these attorneys, because that's another data point that I'm trying to collect. If I were to just speculate, a lot of my cases involve people who are lower income. Higher wealth individuals tend to often have planning documents in place. And so you'd be seeing a big increase, I think, in cost to the county potentially if you went to two attorneys in particular. Stacy Tapke herself, just representing herself as Kenton County Attorney today, would tell you, I like the way it is. I think if you asked my district bench, they'd say they like the way that it is now with the standard of the current standard. But that is not a consensus point among the group.
I appreciate that. Senator Carroll.
Thank you, Mr. Chairman. Stacy, a couple days ago, I received a text from a parent who has a child with an intellectual disability. They recently, well, not recently, it's been a little while, a few years ago, as a matter of fact, went through the guardianship process, obtained guardianship. Their daughter was granted the right to vote through that process. She had some concerns over Amendment 1 that is on the ballot because of the language that is there, that her child might lose the right to vote should that pass. And it uses the term, and this is archaic and really needs to be removed from the language when describing those who shall not have the right to vote. Number 3, idiots and insane persons. And can you, just for those who might be watching, explain the process and the court's role in giving or preserving the right to vote for those who are going through the guardianship process?
So the judge determines who gets to retain the right to vote or not, and it's dependent upon the presentation of the evidence. For example, if you have someone who is unconscious, nonverbal on a ventilator, they probably don't need to be, the judge is probably going to say they don't need to maintain their right to vote because they can't. Versus somebody who's expressed interest. I see a lot of our young adults with autism, for example, very interested in politics and history, and perhaps the determination may be that they retain the right to vote. And at least my judges often want to make sure that that right is retained by the individual where at all possible. A partial guardianship, I don't know the answer to that. I don't think that automatically would mean that your rights to vote would be taken away. I know for driver's licenses, if you have a full guardianship, DOT is informed and you will lose your right to drive if you had a driver's license. A partial guardianship does not mean that you will lose your right to drive.
Very good. Thank you. Thank you, Mr. Chairman.
And there are some cases, as you know, where the judge can allow a respondent to retain the right to vote even after a finding of full guardianship. So that's a great point. We appreciate you raising it. So thank you. Representative Dietz.
Thank you, Mr. Chair. Thank you, Ms. Tapke, who is my county attorney and also a constituent. My question really goes, I think, to number 1 and number 6. My concern is with the reporting that has to be done on the finances and who reviews that to make sure it's accurate. And if it's as simple as it's filed and they've checked a box that they've complied with the statute, or is someone really looking to see how does this compare to the year before, and but for family members that could have some interest in they're exercising their own oversight, how do we make sure that accounts aren't being drained or misused? So I guess 2 parts. One, is it the clerk then? Is there something we need to do where it's more than just checking a box so that we make sure that there's not a dissipation of someone's assets until it's too late? And if that's something we can fix, or if that is something on a form change, because I've seen the form and it's pretty vague. So
it's my understanding, at least in my district court, my judges review those, because if you don't file your reports, you get a nice little letter that says, come see me, by the judge. And I get a ton of phone calls about this particular question because the clerks obviously can't get legal advice. So they say, why don't you call your county attorney? So I do think that this is an area in which that's a great idea about the forms. I will take that back to the working group to see what could be done on the form side from AOC. But I do think this is an area in which there's so much confusion by individuals, because these are people often who they don't know what some of these terms mean, and they're so scared to get in trouble and to not feel like they're doing it correctly. I think there's an opportunity there to make some changes that would benefit everybody.
Representative Nemus.
Thank you, Mr. Chairman. I just want to clarify that Amendment 1 does not add idiots and insane persons in our Constitution. That has been in there since 1890. What the Amendment 1 does is just says that people who are not citizens cannot vote. So the lady that my friend mentioned, that same concern would be, she would have the same concern whether the Amendment 1 were on the ballot or not. Again, that was in 1890, put in our Constitution. We should remove that language. I think it's intemperate. I think it's very offensive. But that is not part of Amendment 1. Thank you, Mr. Chairman.
Thank you, Senator Storm.
Thank you, Mr. Chairman. My question goes back to the individuals that are in state guardianship. I think you mentioned about 4,500 individuals. My concern is, how often do individuals who are appointed as their guardian go visit them? And kind of in line with what my colleague mentioned about the report that's filed, I file a report for one person once a year, and then every other year we file 2 reports. So how often are these people who are the state guardians filing reports?
Do you mean the state guardianship team, someone who's under a state guardian?
Yes, these individuals who are on page 3, the 4,500 people who are in state custody or state guardianship.
The state guardianship team caseworker would be filing that report as set out by the judge's requirements, I believe. I don't want to say 100%, but that would be my understanding, because any guardian would have to file those reports as you're talking about. One report usually is where they are, how they're doing. The other report is about their finances.
We have about 2 or 3 minutes here before 1, so that's one I want to end.
Just curious if those individuals actually go see those folks and interact with them, or if they're getting reviewing medical records only, or if they're having any sort of interaction. Thank you.
I'm sorry, Senator Storm, I don't know the answer to that. We can certainly check with the state guardianship team and try to get some answers to that question for you.
Thank you, members, and thank you, County Attorney Tapke. We appreciate your presentation, and everyone else who was here today. Our next meeting will be on Thursday, November the 7th at 11 a.m., so we'll stand adjourned.